Motion and Limine. While most of us are aware of discovery, and discovery being pretrial proceeding, whereby you try to gather as much as you can so that you can be afforded due process. And if they don't provide it, they can't move forward. See, while many of us have been introduced to certain tools, we stick to it, which is good. But on the other end, there are many more tools that can be used to destroy the tools that we're familiar with and are acclimated with. And emotional limine is one of them. Let me tell you how powerful and dangerous this tool is. You can request discovery, and the other party who provides you that same information as a form of self-confession, because when you really think about it, discovery is self-confession, will put an emotional limine to say, you see that evidence that I just gave that guy? Well, this is speaking to the acting judge. Go ahead and remove it from the document. Make sure that he or she does not use it to support their claim in the future. And that tool is called emotional limine, meaning you, the opposing party, can get all you want. But if emotional limine or an limine is accepted and granted, you would just have all the evidence you want, but you will not be able to put it into use. So key things to keep this short and proper. Emotional limine is used during pre-trial. It's always before the trial. And acting judges are not going to tell you that you have the right to prevent certain evidence from even being put in. Now, before anyone gets confused, motion to eliminate is different from motion to suppress, and motion to eliminate is different from motion to strike. And I'll explain it. See, a motion to suppress and a motion to strike can be used during trial and post-trial. Motion to eliminate is before trial. A motion to eliminate, compared to motion to strike and a motion to suppress, is a preventative measure. Like the phrase, prevention is better than cure. To strike and to suppress is trying to cure something that's already been deficient one way or the other, like an error in the court. So now you have to fix it. A motion to eliminate prevents that from happening. Everyone speaks about equity this, equity jurisdiction, equity that. See this thing called motion to eliminate? That's an equitable relief. The motion to eliminate stops someone from being able to even do something in the first place. To suppress an evidence is to already have something already admitted onto the record. And then you're saying, well, for one reason or the other, even though you have admitted it, I want you to just pull the rug over it and let's act like it's not even there. Motion to strike is to say, you know what, even though this has been admitted, let's just remove it off the record as though it never existed in the first place. Remove it completely. Don't even look at it. Let's not pull the rug over it. Let's just completely sweep it off. Emotional limit, on the other hand, is saying before he puts that stuff over there, make sure that he doesn't get to do it. Emotional limit is that guard at the door that basically gives you that heavy hand and say, no, you're not going to do this. If you want to invoke equitable jurisdiction, the language is the jurisdiction. The language of the law is the jurisdiction. The things that you put on paper becomes law if there's no oppositions to it successfully. It will try to, counteract this, but there are many more tools that you can use to keep this up. But for now, we'll just stay with the basics. Motion to eliminate. And the jurisdiction is determined by the type of relief that you're seeking. The relief that exists at law are similar in some ways, but in the most part, different from that which exists in equity. And motion to eliminate invokes equity. It precedes certain things and supersedes certain things. So during pre-trial, discovery is not the only tool you have. Ask for discovery. Ask for information to buy you some time, to basically set up your motion to dismiss that, hey, look, they're not affording me due process by giving me this information. Let's just dismiss this claim because I cannot properly prepare for a defense. But if you know that somewhere along the line the opposing party are going to hit you hard, independent of the information that you now have to use as an ammunition based on their self-confession called discovery, your tool is motion in limine. So motion in limine is based on rules of evidence. It's used to do two things. The first one is to exclude evidence, meaning before the evidence gets in, you would remove it from the equation so that it doesn't even come to light at all, rather than trying to get rid of it later one way or the other through motion to strike or motion to suppress. Now, the secondary way that it's used is to actually include information. So you can use it to exclude information, and you can use it to include also. And if you know how to use a motion in limine, you will pair it up with a discovery properly. It speaks for itself. And the thing about equitable moves is, compared to at-law moves, you always want to structure your equitable motions like you would like a suit, meaning you have a section that specifically requests for relief to be granted, and you will list it plainly, exactly what you want the relief and the remedy to be, and your intent, so that miscarriage of justice cannot take place. Because if that evidence is admitted, justice cannot be done. If that evidence is admitted, it will be contrary to due process. It would waste the court's time and court's resource. It will waste your time and your resource in trying to suppress it, strike it, or gather further evidence to counteract that evidence. And many more reasons. It will be frivolous, it will be a meritorious entry, it will be vexatious litigation. It would have no fact supporting it beyond hearsay. And instead of going through the dynamics of qualifying an evidence that has an exception of an hearsay or not, wasting all that time to stop it from coming in the first place. And motion in limine is one of the most difficult types of motions to oppose. See, a complaint, if you're a plaintiff and you bring a complaint, all it takes is just a motion to dismiss your response to that complaint. But a motion in limine is far more difficult because it attacks the core of everything, the evidence. So we've been speaking about evidences in the past. The worst case scenario is when you have to learn about hearsay exceptions and the different types of objections, etc., and all that stuff. But a motion in limine will supersede and suspend and prevent all that from happening. A pretrial motion asking that certain evidence be found inadmissible, meaning it's preemptory, and that it not be referred to or offered at trial, meaning you're stopping them right from the start that they can't do this. You are setting the record straight. You are creating the path and the foundation and the pace of how everything is going to go. It is an injunction. Estoppel and injunctions come in many different forms. So get past the buzzwords of estoppel, get past the buzzword of injunction, and know that the tools that are used as vehicles to enforce these buzzwords exist. Look for those tools and put it to use. Attorneys will use this and kick your ass. If you look at all these public disputes about some guy doing something ridiculous and the whole world going awry and being upset, riot and all this, and at the end they say, oh, he's not guilty, and everybody gets upset. 8 out of 10 circumstances like that, when you read the court cases, the tool that broke that expectation of the general public of saying, yeah, that guy must be made guilty because he did something undisputably wrong, beyond reasonable doubt. You know how that opposing attorney that they hired, how he made sure that that reasonable expectation that that guy will be guilty was removed out of the equation? A motion to eliminate. All these, look at any public situation where someone was done wrong that the whole North America knows about. Go into the court dockets. And there will always be a turning point. And that turning point is before trial where a motion to eliminate was done. Pay attention to these subtleties. You can put it to use also. At least you can't say if someone never told you. If this is your first time hearing about this, which I'm quite certain it most likely is, put it to use. Motion to eliminate is one of the hidden secrets. See, within the rules of civil procedure and criminal procedure in your state and federal level, they will give words and terms like discovery. And they'll, like the stuff people know about motion for discovery, they will use those terms openly. But things like motion to eliminate, they will not use these terms openly. But it exists nonetheless. Put it to use. Literally, put it to use. One of the reasons why debt collectors come after people and people know that's not right. Banks are coming after people and you all know that's not right. But how do you actually enforce what you know is not right? A motion to eliminate. Prevent them from putting all that trash in the first place. You wonder why cases go on for 1 year, 2 years, 3 years, 5 years, 10 years. The reason why these cases go on and on as though it will never end, besides the monetary incentive for them, it's because somebody at some point failed to do a motion to eliminate. This is also another way to cut everything short. If you read your state or federal constitution, it will tell you everybody has a right to a fair and impartial hearing without delay or a speedy trial. Motion to eliminate is one of the tools of how you get speedy trial. Motion to eliminate is one of the tools of how you get remedy without delay. So the mere verbiage in all these laws and all these codes that are in harmony with these laws, it's not the limitation. All these laws and codes are compressed into tools. They take shape and form for them to be able to be used. There's a vehicle that you use to ride those verbiage out. So if you for some reason still think you don't use motions, that's fine. Learn the basics of what an affidavit is. Learn the basics of how documents are self-authenticating, which we've went over. And then know what it means to move a court. Know how you get performance based on contract and consideration. The consideration for a court to perform is your motion. Motion just means to move. Otherwise, everything is stagnant. Wonder why you put something in and they just put it in abeyance, temporarily put it on the side? Or you wonder why it's been 3-4 months and the judge hasn't said anything? Yeah, it's because you haven't moved them. Again, at least you cannot say if somebody never told you. All these solutions exist in abundance. You wonder how people make money suing debt collectors. I'm not talking about people who just remove inquiries and that's it. No. If you removed it, then that's money waiting for you. You know how you can make money from that? You know one of the main tools, people who actually make a living off of this, I'm talking about making a good amount of money just suing these debt collectors. You know what one of the primary tools they use? It's this right here. You hear everyone say, attorneys argue. You don't go in there and argue. You want to stay in honor. You know how you stay in honor and don't argue? A motion to eliminate. This prevents argument automatically. This compels them to stay in honor automatically. This gives you power to control the pace. You know, the good part is about any type of motions, while many people might want to run away from it because they don't know how to use it and what it constitutes and what an affidavit is. And the fact that an affidavit can be a motion. An emotion can be an affidavit. You know what the good part about this motion is? Or any motion? You can do it more than once. The beautiful part is, even way more is, if they deny the motion, they would always give you a reason why they deny it. So do it again and fix it. It is very easy to look at a denial from the opposing end and automatically get stimulated and get upset. When in truth, all you have to do is stop and read that piece of paper, and the solution is always handed to you. Best of luck.